The time is now 10 o'clock, and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me today for this meeting are board members Felice Smith, Darrin Sobin, and Melissa Tucker. Together, the four of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask the board members, please take a look at the agenda, and then we'll need a motion to adopt the agenda.
I'll make a motion to adopt the agenda.
Okay, so it's been moved and seconded that we adopt the agenda for today's meeting. All in favor, please indicate by saying aye.
Aye.
Hearing no nays, the board has adopted the agenda for today's meeting. Also before us today are the May 2026 draft meeting minutes, and will a member make a motion that we consider approval of the meeting's minutes from that meeting?
I'll go one step further. I'll make a motion to approve minutes rather than just consider them.
Is there a second?
A second.
Okay, it's been moved and seconded that the board can approve the minutes from the May 2026 meeting. All in favor, please indicate by saying aye.
Aye.
Any nays? Hearing none, the minutes from May 2026 are adopted. So the next item on our agenda is a report from the Office of Open Government. Director Allen, please proceed.
Thank you, and good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government. I am pleased to present this report on the activities of the Office of Open Government, or OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia government's operations are transparent, open to the public, and promote civic engagement. To that end, the Office of Open Government has enforced the Open Meetings Act, advised on the Freedom of Information Act requirements, and provided training on those transparency laws. OOG has proudly served as advocates for an open and transparent government. Open Meetings Act and Freedom of Information Act advices first, advisory opinions, dismissal of Open Meetings Act complaint, 5th District of the Metropolitan Police Department, MPD, MPD employee, advisory neighborhood commissioner, and United States Attorney for the District of Columbia, number OOG-2026-0008. On June 2nd, I dismissed this complaint in which the complainant alleged that Court Watch DC, the 5th District of MPD, 5D Commander Sean Rooney, ANC Commissioner for 5D08, Juanita Holzendorf, and U.S. Attorney for the District of Columbia, Janine Pirro, engaged in bribery, kickbacks, political favors, and unreported income. I dismissed this complaint pursuant to 3 DCMR Section 10403.1A because the Office of Open Government's Enforcement Authority extends only to violations committed by District of Columbia public bodies defined by DC Official Code Section 2-5743. The entities that were the subject of the complaint, including Court Watch DC, a private non-governmental entity, the Metropolitan Police Department, ANCs, and the U.S. Attorney for the District of Columbia, are not public bodies subject to the Open Meetings Act. I referred the issue of alleged misuse of funds by an ANC commissioner and the U.S. Attorney to the Office of Government Ethics for their review and action if warranted. A copy of the complaint and dismissal letter are in Dropbox. Informal advice. Since the last board meeting, the Office of Open Government has responded informally via email, telephone, or teleconference to requests for assistance as follows: 10 requests for Open Meetings Act advice, 10 requests for Freedom of Information Act advice, and 15 requests for technical assistance with open-dc.gov. Meeting monitoring. OOG staff attends public bodies meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and the Office of Open Government Central Meeting Calendar for public meeting notices and records. The Office of Open Government's attorneys provide legal advice on Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG's legal staff have attended 14 public body meetings and no corrective measures were communicated to the public bodies. Training and outreach. First District of Columbia Federal Credit Union Information Session. On May 7th, trial attorney Brandon Lewis and paralegal specialist Kimberly Brown attended this training session held at our offices. It covered financial services, resources, and benefits available to D.C. government employees. Bega Wellness Event. On May 7th, paralegal specialist Brown attended Smile Therapy Workshop, a segment of Bega's wellness event facilitated by Christy Venable, founder and CEO of Smile Therapy Services, LLC in Washington, D.C. The Attorney General for the District of Columbia Appropriations 101 training. On May 13th, I, along with Attorney Advisor Skirbo, attended the Office of the Attorney General for the District of Columbia Appropriations 101 training facilitated by Lori Ensworth, Senior Assistant Attorney General. The training covered the basic concepts in federal appropriations law, the federal and local anti-deficiency acts and their operations in the District of Columbia government's budgeting, spending, and operations. Open Meetings Act training for local school advisory teams. On May 13th, Attorney Lelma facilitated this training for the D.C. Public School local school advisory teams on the Open Meetings Act. The training was the second in OOG's 2026 training series for the LSATs. Attorney Skirbo attended this training virtually. The U.S. Department of Justice Office of Information Policy FOIA litigation training. On May 13th, Attorney Lelma attended this training, which covered grounds for dismissal, the use of and preparation of bond indices and declarations, and attorney's fees and litigation costs. OMA and Robert's Rules of Order training for the D.C. Department of Health Professional Licensing Boards. On May 14th, Chief Counsel Neal and Attorney Lewis facilitated this training for the D.C. Health Professional Licensing Board members at the D.C. Department of Health Interprofessional Board Chair Collaborative Symposium held at Shannon Place in Washington, D.C. Commonly used D.C. FOIA exemptions and redaction training to D.C. FOIA officers. On May 14th, Attorney Lelma presented this training, which is the third session in OOG's FY 2026 FOIA training series. The session covered the most frequently used FOIA exemptions based on the district's annual FOIA report, how to properly apply these FOIA exemptions, and redact responsive exempt information in accordance with DC FOIA. The training discussed applicable case law and provided key points for preparing response letters to requesters. I, along with OOG staff, attended this training. Last is Open Meetings Act training for public body members and staff. On May 14th, Attorney Lewis facilitated this training for D.C. public body members and staff. That was the second training in our FY 2026 General Open Meetings Act training series. Litigation and legislative update. Litigation is first. Council of the District of Columbia versus Muriel Bowser, case number 2026-CAB-001463 in D.C. Superior Court. This is an update on the lawsuit filed by the Council of the District of Columbia against Mayor Muriel Bowser in her official capacity. The complaint alleges that the mayor unlawfully refused to provide the council with certain agency budget enhancement requests for fiscal years 25 and 26 requested by council committees as part of the council's ongoing performance oversight. The complaint further alleges that the council anticipates the mayor's refusal to provide any budget enhancement requests for FY 2027. On May 15th, the court granted summary judgment with respect to the council's claim for budget enhancement requests for fiscal year 25 and fiscal year 26. The court stated, quote, because the council seeks the documents to assist in its consideration of the fiscal year 2027 budget, which is currently under review and scheduled for votes on June 9th and 23rd, 2026, the court finds expressly that there is no just reason to delay entering judgment and injunctive relief as to this portion of plaintiff's claim. The court ordered Mayor Bowser to provide the council with those agency budget enhancement requests for FY25 and FY26 for those agency budget enhancement requests requested by the council committees as part of the FY25 and FY26 performance oversight process. Next is DC Open Government Coalition versus the District of Columbia, case number 2023-CAB-0072151 in DC Superior Court. I have also previously reported on this case, which involves the DC Open Government's lawsuit against the District of Columbia seeking an accounting of the backlog of public records requests submitted through the FOIA Express public access link. On May 27th, the court issued an order granting in part the plaintiff's motion for reconsideration. The court found that the district misconstrued the court's order as a sanction. In this regard, the court stated that, quote, considering the situation as a whole, the transition to a new platform, the representations to Judge Lee, and the timing of plaintiff's requests relative to the transition, it was not reasonable to fail to conduct a search while the data was intact, end quote. The court found that the district had not carried its burden to establish that a reasonable search during the operative window would have exceeded 8 hours and therefore has not adequately explained its search. As such, while the court acknowledged the basis for its order required clarification, it declined to consider the result. The court further found that the district did not raise any exemptions as the basis for its withholding of records in response to the fifth request, nor did it raise an exemption in its briefing on summary judgment. Thus, the court had no duty to determine whether the exempt material could be segregated. The court amended its mandate to require the district to search for and produce records responsive to the fifth request, but provided that it may redact or withhold material covered by a statutory exemption and may exert a segregability argument if one arises. The court also provided that the plaintiff may seek the court's review of any redactions and withholdings. Lastly, with respect to cost, the court found that the issue of cost was not raised in the parties' cross motions for summary judgment, nor was it addressed sua sponte in the court's order. Thus, a motion for reconsideration was not an appropriate avenue for raising new arguments not raised in the previous motion. The court directed supplemental briefing on the issue to be cited together with the plaintiff's motion for attorney's fees. Copies of the reference litigation-related documents have been added to Dropbox, and OOG staff will continue to monitor these cases. Uh-oh. I think I'm missing a page. Thank you. Legislation is next. Open Meetings Clarification Amendment of 2026. During the additional meeting of the Committee of the Whole on June 2nd, the Council Committee of the Whole marked up Bill 26-208, the Open Meetings Clarification Amendment Act of 2026. Councilmember Charles Allen asked to move the bill to the non-consent agenda of the legislative meeting and stated that he had an amendment regarding post-hoc meeting reporting of closed meetings that he would be offering. Councilmember Janice Lewis-George asked the chairman about the number of closed meetings that the council had since the passage of the initial emergency and temporary legislation, and further asked if consideration of the bill could be moved to the next legislative meeting. Councilmember Matt Furman expressed concerns and seconded Councilmember Lewis-George's request to postpone consideration. Councilmember Zachary Parker indicated that in the wake of the emergency and temporary legislation, he had heard from the community that there were concerns with the way the issue has proceeded and that a permanent change to the OMA could be abused in the future. Councilmember Allen indicated that he agreed with Councilmember Parker's concern that the permanent alterations to the Open Meetings Act could serve as an excuse by future chairs and councils to further restrict openness. The Committee of the Whole conducted a roll call vote on both the bill and the report, with Chairman Mendelson, Councilmembers Bonds, Pinto, Felder, and Crawford voting yes, Councilmember Robert White, Trayon White, Parker, Henderson, Furman, and Nadeau voting present, and Councilmembers Allen and Louis George voted no. During the subsequent regularly scheduled legislative meeting on the same day, the Council considered the bill on the non-consent agenda with amendment by Councilmember Allen. The amendment reads as follows, quote, adds a new post hoc requirement for gatherings of council members that are otherwise not subject to the Open Meetings Act, which would require that gatherings of a quorum of the council, whether formal or informal, regular, special, or emergency, at which council members engage in activity defined in the OMA as a meeting where the gathering of council members was not otherwise noticed in advance, be noticed to the secretary. The notice would have to include certain information and requirements to ensure transparency and assist the secretary in fulfilling this responsibility. The measure passed first reading as amended by a vote of 10 yes, 2 council members, Allen and Louis George voting no, and Councilmember Trayon White voting present. Emergency and temporary amendments to the body-worn camera Regulation and Reporting Requirements Act of 2015, this is FOIA-related law, Act 26-0290, the Full Accountability and Arrest Reporting Amendment Act of 2026. This act requires MPD to release body-worn camera footage whenever an MPD officer is present during a serious use of force incident, even if the use of force was by a federal officer, and it also requires the release of names of all law enforcement officers involved. This act will expire on June 29, 2026. Act 26-0304, the Full Accountability and Arrest Reporting Temporary Amendment Act of 2026. This act was transmitted to Congress with the same subject matter with a projected law date of June 17, 2026. The temporary law will be in effect 225 days from the date of having taken effect. Act 26-305, the Body-Worn Camera Transparency for Use of Force Amendment Act of 2026. The act requires the Metropolitan Police Department to release body-worn camera recordings in the event of an officer-involved death or serious use of force by a law enforcement officer other than MPD officer. It was transmitted to Congress, and the projected law date is June 17, 2026. The temporary law will be in effect 225 days from the date of having taken effect. Legislative action regarding various sections of the D.C. Code, including Section 5-113.06, which is FOIA-related, and the Secure D.C. Omnibus Amendment Act of 2024. On April 27th, at the request of the mayor, Chairman Mendelson introduced Bill 26-0671, Protecting Victims Amendment Act of 2026, which was referred to the Committee on the Judiciary and Public Safety on May 5th. The measure would, quote, hold offenders accountable for repeated violations of temporary civil protection orders, as well as stay away and no contact orders in criminal cases, end quote. In part, the bill would deal with personal information of crime victims. Specifically, the bill's memorandum states, quote, to further protect victim privacy, the bill amends MPD's public disclosure requirements to prevent the improper release of identifying information for crime victims, including domestic violence victims, as well as individuals who report on their behalf. The fiscal impact statement states, quote, district law provides for the address confidentiality program administered administered by the Office of Victim Services and Justice Grants. It authorizes a substitute for victims of domestic violence, sexual offenses, trafficking, or stalking to protect their actual address from DC FOIA. District law also withholds ACP participants' information from public inspection as required for records maintained by MPD. The bill provides that victims of or witnesses to a criminal offense may be added to the Address Confidentiality Program. DC Hospitality Amendment Act of 2026, protests concerning alcohol beverage licenses, which is also FOIA related. On March 20th, 2026, at the request of the mayor, Chairman Mendelson introduced Bill 26-0648, the DC Hospitality Amendment Act of 2026. The measure was referred to the Committee on Public Works and Operations on March 31st and published in the DC Register on April 3rd. The bill would create a pop-up license category and addresses issues specific to the category. In terms of DC FOIA, quote, the board shall make a licensee's quarterly statements available to any protestant and to any member of the public who request it pursuant to DC FOIA for the purpose of allowing a protestant of a license to determine the gross annual receipts of a licensee. The disclosure of a quarterly statement to a protestant under this paragraph or to a member of the public who requests it shall be subject to the disclosure exemptions set forth in Section 204 of FOIA. Copies of the referenced legislation and related documents have been added to Dropbox, and OOG staff will continue to monitor the Council's open government-related legislative action. Last is administrative matters. The only matter is the FY 2027 budget oversight. The Committee on the Judiciary and Public Safety did not conduct a budget oversight hearing for Bega's FY 2027 budget. The committee recommended adopting the mayor's proposed budget for Bega. The committee's recommendation is currently under review by the Council Chairman and Council Budget Office. On June 9th, the DC Council Committee of the Whole is scheduled to consider the FY 2027 budget package. This concludes the Office of Open Government's June 4th, 2026 report. I'm happy to answer any questions the board may have. Thank you.
Thank you, Director Allen. Are there any questions for Director Allen? Okay, no questions. Then we'll move to the next item on the agenda, and this is a report from the Director of the Office of Government Ethics. Director Cooks, please proceed.
Good morning, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, the Director of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have a grand total of 80. Open undocketed matters, we have a grand total of 9. Pending state investigations by status, we have 32 matters that are closed pending collection. 3 matters stayed pending DC Superior Court case. 2 matters stayed for U.S. District Court case for a grand total of 37. For regulatory matters by status, we have 62 matters that are closed pending collection, 635 matters that are open for a grand total of 697. Again, we currently have 80 matters that are open and 5 matters that are stayed. The number of open preliminary and formal investigations includes 22 new matters. The investigative team resolved 18 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. The quarterly complaint was...
I'm sorry, can I stop you just a second? Since we're going over these numbers anyway. We got, the way I'm reading this, we got 80 open investigations, right? And then, but if you go down, the number is 635. How do we get from the 80 to the 635?
We have 80 open investigations, which accounts for preliminary and formal matters. Mm-hmm. We have 635 regulatory matters. Those are
regulatory matters.
Yes. Okay. Those are your FDS and lobbyist matters.
Got it. Okay. That makes sense. Thank you. Sorry to interrupt.
The number of open preliminary and formal investigations includes 22 new matters. The investigative team resolved 18 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. The quarterly complaint report for quarter 2 of fiscal year 2027, covering period from January 1st, 2026 to March 31st, 2026, was published to the Bega website with a press release and heat map. During quarter 2, OGE closed 124 matters. Less than half of the matters, 55 out of 124, involved allegations that were outside of Bega's jurisdiction. For the 69 closed matters within Bega's jurisdictions, allegations involving rules governing outside employment or activities accounted for 23 matters, while allegations involving misuse of government property accounted for 13 matters, and alleged violations of the nepotism rule were involved in 12 matters. There were 7 matters stemming from allegations involving violations of the conflict of interest rule, and 6 matters alleging preferential treatment or lack of impartiality. 3 complaints allege use of public office for private gain, and 2 matters involve violations of rules governing gifts and donations. There was 1 matter in each of the remaining categories. Copies of the quarterly report, heat map, and press release were placed in the Dropbox. Next is an update on training and outreach. First, professional development trainings attended by staff. Since the last board meeting, Chief of Staff Christina Mitchell completed PeopleSoft course, thermostats, and thermometers. For trainings conducted by staff, since the last board meeting, OGE conducted 6 training sessions, a board and commissions ethics training, the May monthly ethics training, the May Hatch Act training, the monthly brown bag session, and 2 new employee orientations. In May, 616 learners completed courses on the LMS. 5,526 district employees completed ethics training using PeopleSoft, and 117 new employees attended new employee orientation and received information on the district's ethics rules in May. For advisory opinions and advice, first is informal advice. OGE's legal staff provided advice for approximately 40 ethics inquiries, which is 2 less than the 42 reported at the May board meeting. This number does not include responses we have provided to questions regarding the lobbyist and FDSE filing systems. For formal advisory opinions, OGE has not issued any formal advisory opinions since the last meeting. The comment period for the formal advisory opinion representation through testimony, which was issued in April, closes on June 15, 2026. Next is an update on legislation and rulemaking. The financial disclosure statement rulemaking, B26-0325, Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025 is still pending. This legislation is in response to Bega's rulemaking, which designated 43 board and commissions as public financial disclosure statement filers and will repeal Bega's authority to make such designations in the future. On April 18, 2026, the Council passed B26-0632, Open Meetings Clarification Amendment, Emergency Amendment Act of 2026, which halts the applicability of Bega's rulemaking until October 17, 2026. Council Chairman Mendelson has indicated that he will amend this legislation with the intent that it passes before the Council's recess. Next is an update on OGE administrative matters. First is staffing. OGE has an attorney advisor vacancy, which we plan to fill in the coming months. Regarding the budget, on April 10th, the mayor submitted her FY27 budget and budget support act to the council. Bega's proposed budget is $4 million. The Budget Support Act proposes a transfer of $28,000 from the lobbyist fund for fiscal years 2027 through 2030, and a transfer of $19,000 from the accountability fund in fiscal year 2030. These transfers were in addition to the already existing sweeps that were passed by the FY26 BSA. On May 22nd, the Committee on Judiciary and Public Safety issued its report and recommendations on fiscal year 2027 budget for agencies under its purview. The committee adopts the mayor's proposed budget for Bega. The committee also proposes BSA subtitles, which will amend the lobbyist section of the Ethics Act. Specifically, the amendment will increase registration fees by $150, which means general lobbyists will pay $500 and nonprofits will pay $250, with the additional $150 going to the district's general fund. The amendment also will require 501c4 organizations to register as lobbyists, increase the late filing penalty to $200 per day, and remove the exclusion of Saturdays, Sundays, and weekends from the late filing time frame. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees must file a financial disclosure statement as a means of transparency and to prevent engaging in conduct that violates the financial conflict of interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statement. The deadline to file the financial disclosure statements for this season was May 15, 2026. The FDS team sent out initial mailer notices on April 15th. The team also sent out hard copies to all public filers and will continue to send reminders to those who have not yet filed. As of May 29th, 8,055 filers, which is 90%, completed their financial disclosure statements. Next is an update on lobbyist registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27a, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the registrant's lobbying activity during the previous quarter. As of May 2026, we received 97 new lobbyist registrations and 939 activity reports. On May 6, 2026, fine notices were sent to 7 lobbyists, and this week, 2 fine notices were sent out. Last is an update on public investigations. 25-0005F in Refill Mendelson. This is a formal investigation based on allegations that the respondent, chairman of the D.C. Council, misused government property and resources to oppose a political candidate's declaration of candidacy with the Board of Elections. Thank you. This concludes the Office of Government Ethics June 4, 2026 report.
Thank you, Director Cooks. Are there any questions for Director Cooks?
I do, actually, if anyone else wants to go first.
Go ahead.
Okay. First, with respect to this legislation for the lobbyists, the new lobbyists, can you hear me? The new lobbyist registration. Can we talk a little bit about that? Because it seems like it's even harsher than what we're doing. And we just increased, our fines, and we're suddenly getting all these huge fines. But now the council wants to do an additional, so they want to take away not counting Saturdays and Sundays and holidays. And what else? They want to increase, they want to double the amount of the registration fee.
Correct.
For profit-based lobbyists, but they want that money.
Correct. So the council has proposed, as a way to generate revenue for the district, increasing lobbyist registration fees by $150 for the for-profit entities, which would go from $350 to $500, and the nonprofit entities, which will go from $100 to $250, and the extra $150 would go to the district's general fund. In addition to that, the council is proposing to increase the late filing penalty, which is currently $100 per day up to 60 days, to $200 per day up to 60 days. And they also have included that 501c4s should register in the same manner as 501c3s. And that, yes, we would exclude Saturdays, Sundays, and weekends from counting of late registration filings.
All right. And this came from the council, not the mayor?
Correct. We did submit a proposal to the mayor to exclude the weekends, Saturdays, Sundays, and holidays, and to include 501c4s. The mayor, when she submitted her budget to the council, she only included the exclusion of the weekends, but this is the council's chance to amend the BSA. So this is coming from the council, yeah.
Any particular council member behind this?
Councilmember Pinto.
Interesting. So, okay. Well, we know where the council stands on leniency toward lobbyists. The other question I had was, and I appreciate you doing this because this came up when we went for our confirmation proceedings about where the complaints are coming from and what are the things that are being violated. And so thank you for breaking it down for us. I'm not surprised to see in our quarterly report that misuse of government property and outside employment are the top two. I'm very surprised to see that nepotism is a very close third. Is that unusual? I can't remember from the last time, but that's alarming if nepotism is number 3.
It is usually lower on our chart of receiving complaints, nepotism. So this is unusually high for nepotism.
Can you?
But of those matters, there wasn't any evidence found of nepotism. So I guess just to say that folks are submitting complaints for it does not indicate that there's an increase of nepotism within the district government, because we closed those matters for lack of evidence.
I got it. All right. Well, that's fine then. Okay, that's it. Thank you.
Thank you. Thank you, Director Cooks. Next on the agenda are public comments. Members of the public in attendance at this meeting have an opportunity to make a comment at this time. Are there any members of the public wishing to make a comment? And seeing none, there are no comments from the public, so we'll proceed to the next item on the agenda. And this is our executive or closed session. This is to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B4, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
Second.
It's been moved and seconded that the board enter into the executive session. All in favor, please indicate by saying aye.
Aye.
Okay. No nays. So now board members will move over to the boardroom for the executive session. We will return to this meeting after the conclusion of the executive session to report out any matters decided, finish any other business, and adjourn the meeting. Thank you. Okay, we are back on the record. The time is now 12:29 p.m. And in its closed session, the board established a new hearing date for 26-0002F in re Cleo Sabito, and the board issued a final decision in 25-002-F in re Trayon White. Okay. Now 12:30, and this concludes the meeting of the DC Board of Ethics and Government Accountability for the month of June. The next meeting will be held at the Board of Ethics and Government Accountability, 1230 15th Street Northwest, Suite 700 West, and virtually on July 9th, 2026 at 10 a.m. Thank you.
Thank you, Amber.
Yes. Have a good 4th of July. We won't be back before then.
Juneteenth.
Okay.